Hello everyone, welcome back to Texas Government. Today we are going to go over the first part of the Texas judiciary system. So some of the key terms to know are adversarial system, plaintiff, and defendant. Of course, the judicial system is an adversarial system by definition. This means that there is two parties at the very least that have some sort of conflict between them. In criminal cases, of course, the conflict will extend between the state, who is the one bringing the charges, and the person accused of having committed a crime. In a civil action, it is the person, the plaintiff, who is bringing the charge against someone else, who is the defendant. The plaintiff is always the party that is bringing forth the lawsuit, whether it is a civil case or a criminal matter. The defendant, of course, is always the party that is having to respond to the charges that have been brought against them. Now, the first type of case that we will talk about is civil law. So these are civil cases. Now, again, I have provided you a link to various civil codes that are in the state of Texas. Please feel free to link through and see some of the civil laws that are in place. Now, civil law deals primarily with individual or property rights. This is people versus people, company versus company, or an individual versus a company, or vice versa. The purpose, of course, is to assign responsibility to the party, to the defendant, not guilt. We are not talking about innocence or guilty. We are talking about whether or not someone has committed a wrong against you and how responsible are they for that wrong. In a civil case, the plaintiff and the defendant are often private parties. It is not 100% surety that both parties will be private, but more likely than not, the individuals involved in this are actual individual persons or companies. Of course, in a civil law case, the disputes are usually set out in a petition. The petition is the first document that is filed in a new lawsuit, and in this first document, in this petition, the plaintiff is setting out how they have been wronged. Now, in order for the plaintiff to prevail in their case, a jury or a judge, whomever is deciding the case, has to reach a decision based on a preponderance of evidence. Usually in TVs and movies, you always hear beyond a reasonable doubt. Well, that only pertains to criminal matters. In a civil law case, you win your case by convincing a judge or the jury that there is a preponderance of evidence, meaning the evidence is overwhelmingly in your favor. Of course, in a civil law case, the remedy that you are seeking is compensation for the violation of whatever legal rights you have asserted. You have asserted that that the other party, whether an individual or a company, has violated some sort of law, some sort of legal code or right that you had. This remedy is going to be in the form of compensation of money. Now, in a criminal law case, criminal law deals with behavior. We are talking about individual behavior as it is defined by law. Now remember, the law is written by the legislature, so the state legislature is defining how you should behave. In criminal law cases, the lawsuit or the case is initiated by a government prosecutor, we are talking about the county district attorney will file a case against a suspected criminal, and this case will spell out the specific charges that this person is accused of having been committed. They will spell out the law that has been broken, and it is up to the suspect to plead guilty or not guilty. Now, in a criminal case, there are very strict rules of procedure that have to be followed because we are dealing with a person's life usually, and punishment is incarceration. So, these strict rules of procedure are used to evaluate all evidence. Of course, in a criminal case, this is where reasonable doubt comes in. In order to find someone guilty, the jury or the judge has to use the evidence to prove beyond a reasonable doubt that this individual is guilty. Now, in a criminal case, determination of guilt will usually result in punishment. This punishment comes in the form of incarceration. It could come in the form of probation, but either way, the determination of guilt will result in some sort of punishment. Now, when it comes to jurisdiction, original jurisdiction is the geographic location for the setting of a trial. Does the court have the ability to hear a case, whether civil or criminal? Now, in original jurisdiction, a judge will oversee the trial. The initial procedures will be done through trial, in which a judge oversees the entire case. It is then up to a jury to evaluate the evidence that has been presented to them, whether in a civil or criminal matter, and reach a verdict. Now, unlike original jurisdiction, appellate jurisdiction deals with the power of a court, of a higher court from the original jurisdiction court, to review the decisions of that original jurisdiction court, which is a lower court. An appellate hearing does not involve a new trial. The proceedings during an appellate hearing are based on law, not fact. What we are trying to understand is whether the original legal proceeding was proper. Reversal of an original proceeding means that the legal process was not proper. The procedures that were followed in that original trial were not proper procedures or did not interpret law correctly. Now, if an individual decides to file an appeal, they are waiving their right against double jeopardy by appealing their case. This is the only time that you have this double jeopardy come in, and that is you end up waiving your right if you file an appeal. Now here I have given you a chart that indicates the levels of the court system here in Texas. At the bottom of the chart you will see the justice courts along with the municipal courts on the same level. We move up to the county courts and the district courts, and then you have the courts of appeal. So what we have are these levels of justice, municipal, county, district, the intermediate courts of appeals, of which there are 14, and then you have the ultimate state highest courts, which are the State Supreme Court and the State Court of Criminal Appeals. In the state of Texas, all civil and juvenile matters are or can be appealed to the highest court in the state, which would be the Supreme Court, the Texas Supreme Court. All criminal matters can go as high as the Texas Court of Criminal Appeals. Now in this slide you can see that there is a link to other state court systems. This is just so that you can do a comparison of the state of Texas to other systems. Please do this at your leisure. It is not something that you will need to know for the test, but it is just something so that you can see for your own information. Now municipal courts, of course, are that very first level of the Texas court system. They are created by the authority of the Constitution. These municipal courts are created by the state legislature. Now, as far as jurisdiction for municipal courts, original jurisdiction for municipal courts is the enforcement of city ordinances. It is also responsible for Class C misdemeanors that originate within the city limits and any civil cases involving dangerous animals, such as dog attacks. So these are Class C misdemeanors, city ordinances. It can be traffic court. This is where you go pay for those speeding tickets, or you have to answer for a citation that you have received if you were involved in an accident. So these are the types of cases that are found in municipal court. Here's just another quick review of what the municipal court is responsible for. As I said, the violations of city ordinances, Class C misdemeanors. Out of municipal court, cases can receive punishments of $500 or less. In municipal court, we are not looking at jail sentences or jail time as a form of punishment, mostly because the cases in municipal court will deal with traffic and parking violations. Now, the number of municipal courts. As of 2019, there were approximately 940 municipal courts across the state. The caseload, though, that is a big number. In the fiscal year 2018, we are looking at almost 494,000 cases filed in Texas. This is across those 940 municipal courts. One of the other duties that a municipal court judge does have is the ability to sign and issue search or arrest warrants. As of 2018, there were approximately 803 courts in the state of Texas. Now, the Justice of the Peace has jurisdiction over criminal cases, and it is usually over, or it will only issue fines of under $500. In civil matters, the dispute has to be less than $10,000. Of course, they issue warrants for search and arrests. Now, in order to be a Justice of the Peace, you have to be a registered voter. You do not have to be a licensed attorney if you are able to take a 40-hour course and pass. It is, however, an elected position. You would be elected to a 4-year term. Now, some of the other duties that Justice of the Peace have to perform is marriages. You can go and be married at the Justice of the Peace Court. The Justice of the Peace can also be responsible for coroner duties. Now, ex officio notary means that they can notarize and attest to records. and of course they are the small claims court. Now the caseloads for the JPs were more than 229,000 cases in 2018. A lot, like I said, the other duties deal with search and arrest warrants in the counties that are out in rural areas or that do not have a medical examiner. They could serve as coroner, and of course they also sign eviction notices. Now we will stop here and then I will pick this up in part 2 of the Texas judiciary system.